All right, good morning, council. We will proceed with the second case on the docket. I'll repeat some preliminary comments I made before the first hearing because I don't think you were able to hear that. First of all, I'm the presiding judge, Thomas E. Malone, for this hearing. We also have Judge Steve Hill and Judge Mike Boozer. We will take up the second case on the docket. Just a few preliminary remarks to council. We have read your briefs, so we understand the facts of the case and what the issues are. You might keep that in mind as you make your argument. Each side is given 15 minutes for your argument. The appellant's attorney should let us know in advance if you wish to reserve any time for rebuttal. After we hear your arguments this morning, your case will be deemed submitted for decision. And after that, we will take the case under advisement and get a written decision out to you and your clients just as soon as we possibly can. So with that, I'll go ahead and call the second case on the docket. It is from Johnson County. It's number 122-737. Entitled Eugene and Victoria Frost versus Kansas Department of Children and Families. Who do we have here for the appellant?
Your Honor, Linus L. Baker, appearing on the behalf of the appellant Eugene and Victoria Frost.
And for the appellee?
Good morning, judges. Mark Altenbernt, A-L-T-E-N-B-E-R-N-T, on behalf of DCF.
All right, Mr. Baker, do you wish to reserve any time for rebuttal?
3 minutes, Your Honor.
That is granted. You can go ahead and begin.
Thank you, Your Honor. For the viewers, this is a grandparent visitation case. It has to do with the interpretation of KSA 233301 et al. I'm going to start with a Kansas Supreme Court decision that was rendered 5 days ago, in which Judge Stegall stated this: if a court can genuinely, reasonably, plausibly, or fairly interpret and construe statutory language consistent with legislative intent in a manner that also preserves it from impermissibly encroaching on a constitutional limits, the court must do so. I don't know that adds, it adds a little bit more flavor to what courts have talked about in construing statutes to avoid a constitutional question. In this case, I believe this panel can construe 233301 and its following counterparts as constitutional by saying that grandparents can file an action, independent action, and that it would include Article 27 of Chapter 23. If you construe it that way, then you can also harmonize what 233303 says. The TNY court looked at this and they said, well, and I'm looking at it, said if the legislature intended subsection B, which is the district court can grant grandparent visitation, to broadly permit grandparent visitation in a variety of actions, it said that subsection A would be superfluous. So I don't believe that's correct, but the TNY court did not provide any analysis whatsoever as to what it meant under 233303. Under that interpretation, it makes 233303 superfluous. And you cannot harmonize it. It makes no sense. An action, a petition, it has a venue provision. That all becomes nonsensical when you say it's only limited to a dissolution proceeding. If it's only an appendage, you certainly don't need a venue. You don't need to provide notice to interested parties, which mimics the language that we get in adoptions and things like that. And then you don't.
Counsel, I have a question for you.
Sure, Judge.
You have sued the Department of Children and Families. Is that correct?
We have, Your Honor.
And what relief are you requesting from them?
They're the ones that have custody of the children. They're the ones that have opposed our obtaining rights to grandparent visitation. They actually have custody of these children. So
What is it you're asking them to do?
we're asking them to not oppose, to allow us to do this.
They did not issue this order. As I understand it, a child in need of care court in Johnson County issued a order restraining your clients from visiting with the children who are, I guess, in DCF custody.
That is correct.
And can this Johnson County District Court, in your separate action, issue an order contradicting the juvenile court's order?
Certainly. And that is because
And is that effective?
it's, well, now that's a different question.
Well, the
district court
statute
says-
certainly doesn't say that.
Well, the statute says you have a right. The statutory scheme says, look, it contemplates that there may be different courts having simultaneous jurisdiction over these children. And in fact, the SYNC statute says that if you have to look at one order versus another order, the SYNC order prevails. But that in and of itself says that you can have concurrent jurisdiction, and there
So
may
Are you simply asking them for an advisory opinion from the district judge on this?
No. So here's the thing. SYNC cannot give my clients the statutory rights of grandparent visitation under 233301. It's impossible. They cannot do it.
Grandparent visitation is ordered all of the time in
Not
district
this,
court.
but not this statutory. That they can only grant temporary. And so they cannot grant this grandparent visitation based on substantial relationship. Now, so if that were true, if I could go to the SYNC court and get this statutory right, not this other right that they can only temporarily grant, but courts have held, Baker v. McCormick being one of them, said, no, sir, you cannot do it anywhere but a dissolution or a paternity action. So they're shut out of court that way. So if they have this statutory right, and they do, then they should be able to proceed in an independent action, which is exactly what they did. That SYNC proceeding will end one day. Whatever orders that court has made, whether it has to do with grandparent visitation or those are going to go away. And we still have these statutory rights that these grandparents are entitled to assert under 233301.
That brings me way back then to the question that I initially asked you. What relief can you get from DCF, even if they say, hey, we don't oppose you, but in this lawsuit, then what can you get from them?
It's not no, well, see, Judge, I brought in DCF because they're an interesting party. The court, the lower court can grant me relief. So it isn't DCF is only there because they're an interested party. If it weren't, then it'd be the parents. So
my problem is I question whether you have a real case in controversy with the Department of Children and Families.
Well, the statute itself, Judge, says that the district court is to tell me who I should notify as interested parties. It doesn't mean that the parents, for example, if the parents still had custody, the parents, the one that can grant relief is DCF in terms of letting these grandparents have grandparent visitation if the court orders it.
But that can only be done in the child in need of care case, because that's the only way DCF has authority to have custody over these children. Is in the child in need of care case.
I couldn't disagree with you more, Judge. DCF is acting as a parent. So who are the interested parties? if they have a grandparent visitation right, you file this independent action. Who do we get into this case now that is the interested party with custody over these children? It is DCF. That is the real contract. Now you say, well, who else would I have sued to get declaratory relief, I guess, or to get this right? I have to file this independent action. The court can declare the rights and say, yes, Eugene and Victoria, you have a right to grandparent visitation, and here are your rights. DCF, being there, they can argue that they shouldn't have grandparent visitations, or they can. But the relief that this court can say is remand this back, recognize the grandparent visitation rights, and proceed accordingly. Now, the next corollary to that is, do they conflict with the sync? That doesn't divest that court of any jurisdiction to make a ruling. And who knows, by the time we get back, that sync proceeding may or may not be over. But what cannot happen is the Frosts go into sync and assert these rights. Under the courts, under this viewpoint, Victoria and Eugene can't even go to court. Who would they ever sue to get these rights under 233301? Give me a defendant that I should sue that have the real party and interest to the custody of these children. It's not the parents, it's DCF. So we're shut out of court because there's a sync proceeding. It cannot follow, Judge. So the statutory analysis here, it does vest into these grandparents that right. And if so, I don't know who you would sue other than DCF. But if there's nobody that we can sue, then we're just shut out of court. Every grandparent will always be shut out of court if there's a sync proceeding pending. That cannot be that statutory right goes away because of sync proceeding. That says that it's essentially divesting all the rights, and there's no concurrent jurisdiction, which was the argument of DCF. The sync statute specifically says that there can be concurrent jurisdiction, and if we're faced with two courts that are making rulings about custody of the children, sync rulings always prevail. You don't have to worry about it.
Mr. Baker, let me ask you a few fact questions.
Sure.
Your petition for visitation that got all this started, that didn't sue anybody, correct? I mean, you didn't sue DCF. It's just Eugene and Victoria Frost requesting visitation, and it asked the court to designate interested parties, right?
That is precisely right, Judge. You go into the court, you ask for the relief, the court tells you who you need to give notice to. So I didn't even mean to name a defendant, but I did.
You didn't name a defendant.
Okay,
you didn't sue anybody is the point I'm trying to make.
Yes, and that's correct. I mean, I brought them in because I thought they were interested parties. They had a dog in the fight.
The second question is, I understand your petition actually covered 4 grandchildren, didn't it? And 3 of them are in DCF custody, but not the 4th. Is that correct?
That is correct. Now, let's be clear. That 4th child, subsequent to this now, they have brought sync proceedings. Now, I don't know, but it's in its infancy. They haven't substantiated it. They haven't said it's a child in need of care, but they have made that petition. Oh, I'm sorry.
Okay.
So that is factually correct, Judge.
All right. You've used about 11 minutes, so you're close to wrapping up your first part.
Okay. So here's the TNY court, the statutory, they said they were saying as applied. They never made any analysis to that. TNY said that they interpreted it contrary to what Judge Stagel said, and they had said that that's unconstitutional and they had to go down this other pathway. And they said that phrase was unconstitutional. It was stricken. Well, that's my point in Baker v. McCormick. If it's stricken, it can't be a little bit stricken. TNY did a facial analysis. They put it in as applied clothing. It doesn't make any sense. They said they could sever it. They clearly expanded the scope of grandparent visitation under their interpretation, which is a statutory no-no. So, you can't use legislative intent when you've got the actual words. And if you construe this even as ambiguous, that the subsection A and then B, and then you go to 233303, you have to harmonize that. And if it's ambiguous, then you choose the pathway that Judge Stagel says, which I say is you can say they contemplated independent actions and they contemplated that you could also file it in a dissolution proceeding. That solves all your equal protection rulings. You don't treat grandparents any differently. You don't treat children any differently. And that resolves that. And so you can give effect to all that language simply by doing it. If you follow TNY, then you cannot sever this language without expanding the scope. The cases that TNY cited, which were Lyman and Morrison. Morrison was, they asked Morrison Court, would you expand or change this Kansas Funeral Privacy Act? And they said that, no, we're going to look at the words. And they said, we declined to engage in such judicial gymnastics. And they said that.
Mr. Baker, let me interrupt you.
Sure.
Under 382201A, it says that sync court orders take precedence over similar orders issued under the Kansas Family Law Code. Do you agree with that?
Oh, I do.
Okay. So currently in the sync case, the grandparents are precluded from visitation by that sync judge, correct?
Well, the sync judge has done more than that. She not only denied it, she said no contact. So yes, yes.
All right.
But that's
So
temporary. That's
So
temporary.
you file a separate action, and I'm the district court judge, and I say, you make some really good points here, Mr. Baker, is for your clients. But I'm looking at 2201A, and it says that the sync court order is going to take precedence. Why would I make an order that would, for example, grant visitation and then have conflicting orders? I don't see how that would be consistent with Kansas law.
Well, yeah. Well, let's look at what sync can do. Sync doesn't look at a substantial relationship. It provides no standard, and it does not provide for any statutory rights. In other words, all they say is that we have discretion to allow grandparents visitation. They're not purporting to vest any kind of statutory rights or the substantial relationship query, and it's temporary. So no, so sure, Judge, the sync judge is not going to use all those factors. I get to come in.
Wait a minute. Let me make this simple.
Okay.
In your action, the judge agrees with you, and so let's say he says, I want to order visitation for the grandparents. Where do we go from there? What happens? Walk me through it.
Well, sure. Okay. So the district court says, yes, Frost, you got a substantial relationship, be in the best interest. All right. I've looked at things the sync court didn't. You didn't have your day in the sync court.
Just walk me through it, Mr. Baker. Finish it up.
All right. So you got that
you
order.
won the case.
Right. Well, the sync order that says no visitation, that's going to prevail. But it does not divest the district court who did the court. Frost had their day in court. That sync court ruling, okay, that prevails, but it expires. It expires.
Right. So as of the time that you present your case to the district court separately, your case and controversy is not in existence yet.
No, sir. It is a controversy because that district court has jurisdiction to grant me those statutory rights, something the sync court is not considering, doesn't even have to give me a day in court to do it. So I cannot be shut out of court and to have those statutory rights because the sync court made without a hearing, without any evidence, due process. Under that theory, Judge, it's the same kind of idea that if a sync proceeding is there, then you've divested all statutory rights and all grandparents. They cannot.
All right, you answered my question. I appreciate it. Thank you.
Thank you, Judge.
Yeah, and you've used well over your time. I'll still give you rebuttal, but you need to stop here.
All right, thank you, Judge.
So we'll proceed with the appellee counsel.
Thank you, judges. And again, Mark Altenburnt on behalf of DCF. Your Honors, before I get into my argument, I wanted to start by addressing a few things that counsel for the appellants said. It seems to me that he's asking this court to take the extraordinary step of changing the law in the state of Kansas on a matter that, quite frankly, is premature. Counsel himself stated during his oral argument that the sync court can, in fact, give his clients visitation. They have that right. It's a temporary order in the sense that the sync case will eventually go away, but the reality is any visitation order is a temporary order because the courts, whether it be the sync court or the district court that counsel filed his action in, they're going to evaluate visitation on the best interest of the children. And that is a snapshot in time. That could change. So for example, let's say this court agrees with counsel that he has a right to go to the separate court and get a visitation order. That's not a permanent order in the sense that this sync case with its no contact order could carry on for 2 or 3 years. This sync case ends, that order is no longer, I mean, it's gone bad in the other court in essence, because it's been 3 years since we've had this best interest of the child analysis. So reality is counsel's already admitted that his clients can get visitation in the sync court.
Counsel, can I interrupt you with some questions?
Sure, absolutely.
Let me, for the sake of argument, let's say I agree with you that the Frost can't file an independent action for visitation to circumvent the sync order. But I guess the question I'm getting at is that jurisdictional? The district court ruled that it did not have jurisdiction to hear the grandparent visitation, the petition filed by the Frost. And I think the court did that based mainly on the TNY case. But I guess my specific question is your statute 38-2201A that gives sync orders precedent. Is it correct to say that that deprived the district court of jurisdiction to even hear the Frost petition?
Judge, I'm not sure I would go so far as to say that it completely deprived them of jurisdiction because of the sync order. I think what the court did is it said it didn't have subject matter jurisdiction because the statute only allows for an independent action to be filed in a divorce case or by extension through the TNY case, a paternity case.
Right.
Either of those. And what the appellants are trying to get this court to do is expand that even further to allow grandparents the right to come into court and seek visitation just because of the status of them as grandparents. If we get to the constitutional issue, which I don't think we need to, but if we get to the constitutional issue of that statute, the TNY case, that court's decision was made because we were dealing with a suspect class, illegitimate children versus children born in wedlock. That was the defining point of that case, and that's where so the court got into intermediate scrutiny and made its determination. This is not that case. In fact, the Baker case that counsel for the appellants was directly involved in, they made that argument. The TNY case just opens the door to any grandparent visitation, and the Baker court said no, it doesn't. It was simply it simply extended it to paternity. Grandparents don't have a fundamental right to have visitation with their kids. Grandparents are not a suspect class. So the ruling in TNY and doesn't apply here. The ruling in Baker does apply here. And on top of it, Judge, we have an additional point. We have a Sink case where a no contact order was entered against these very individuals that are seeking visitation right now.
Before the 2012 amendments to 23-3301A, grandparents filed petitions for independent visitation all the time, didn't they, in Kansas? Like the Frost did in this case. That was very common and allowed. Isn't that correct?
Oh, I can't say whether it was very common that they did that, but it was allowed, yes.
All right. And then we had the 2012 amendments that basically just combined the two statutes together. And the legislative history makes it very clear that it was never intended to be a substantive amendment. But the TNY case came along and declared that now we can no longer have independent grandparent visitation petitions. That's correct? Is what I've just said is a correct summary of everything?
I believe so. I think the TNY case, the TNY court said what it said because that's what the statute said.
Yeah. I'm just having trouble resolve, and maybe we don't even need to get to that with the Baker's case. But I have looked at the history of the statutes, and I've looked at the TNY case, and I'm having a whole lot of trouble resolving why TNY ever came to the conclusion that grandparents can't file independent motions for visitation, because they always could before the statute was amended. It's clear that the statutory amendments were never intended to be substantive, but now we're in this situation where courts rule that grandparents can only intervene in a divorce case or a paternity case, but they can't file independent motions for visitation. And I'm struggling with how we ever got to this point and whether we correctly did so.
Judge Hill, did you?
Counsel, DCF still has custody of these children, correct?
Correct.
What relief can you grant the grandparents at this point?
Realistically, Judge, we can't grant them any visitation. There's a Sink order that takes precedent. Everybody agrees on that. That has entered a no contact order. And the reality is appellants had the opportunity. They still had the opportunity, quite frankly, because the Sink case isn't done.
If you can't provide any relief to the grandparents, do you have a justiciable controversy with them?
Judge, I would say probably not. I think a better way that I try to put it is I think this is premature. It's not necessarily moot, and I don't want to get into the concept of ripeness, but the reality is this is an effort to impact a Sink order that takes precedent over any other order. So I guess we don't understand what the...
Why do you not want to get into the idea of ripeness? It seems to me to be a classic case of ripeness.
Well, I would agree with you, Your Honor. I think
well, now that I've said that, you agree.
No,
with
when you use the term ripeness, it gets in a different constitutional analysis. But I would agree. I don't think this issue is ripe for a decision at this point, because it doesn't matter what happens with the independent action. The Sink court rules the day.
The only reason why these grandparents haven't had any visitation with these grandchildren is because of the Child in Need of Care Court's order. Is that correct?
That is correct. I would add on to that that since the Sink case began, the grandparents have never sought visitation, even though they have the right to. They've never asked for it in the Sink case, at least not formally. And counsel's giving me a look, but he himself has admitted they can seek visitation in the Sink case.
But in all fairness, he's arguing that no, we want something bigger than that. We want something, we want a permanent order from a court that's not involved in a child in need of care that says we shall forever have visitation or something, something that's more permanent because of what you have referred to as the temporary nature of child in need of care orders.
Well, I think that's correct. That's what they're seeking. I think that there's a misunderstanding in terms of what constitutes permanency and what constitutes temporariness.
So my next question to you then is, can the Department of Children and Families provide that relief?
We can't provide it. Let's assume for the sake of argument that they get that they have their hearing and that the judge gives them visitation in this independent action. We can't, it's a nullity in essence, because nobody can resolve that order. Nobody can give them the visitation. The Sink court has entered their order of no contact. And until that changes, or until that Sink case ends, there's no relief that can be given to the appellants. Now
there was some argument in the briefs that said, well, this could be persuasive authority, that he could then go back to the child in need of care case. Look at this, Judge. Look, this other judge says we should have visitation. What's your response to that?
Well, Judge, ultimately that's the underlying point of this entire action. This isn't a situation. This wasn't done by the appellants because they couldn't do the same thing and get relief in the court. They could. This was done because they believe the Sink court is biased, because they believe the Sink court isn't going to give them the time of day. And this isn't me do conspiracy. These things were stated in open court. At the same time, counsel stated what Your Honor just referenced. That's why the independent action's been done, because they don't like the judge in the Sink action. That's why they tried to get her off the case. In fact, they even tried to disqualify my predecessor from being the attorney for DCF. So that's why this is at its root an improper collateral attack on the Sink order. It's been dressed up as some constitutional, they have rights picture, but at the end of the day, we have a Sink case that determines visitation, and the people that are trying to get visitation in this illegal independent action are in fact the people who were said you can't have contact with these kids because it's not in their best interest. So that's a very long way of me saying I don't think we need to get to the equal protection argument or why the statute changed for what it doesn't matter, because we have this Sink case that has jurisdiction. It doesn't necessarily divest the other court of jurisdiction, but what it does do is it says whatever you do over there, if it's different than what we do, it's not happening. And on top of all of that,
you might be arguing against yourself, counsel, that the district court dismissed this case for lack of jurisdiction.
Oh,
That's what I was getting at in my prior question is why does the district, does that Sink statute, I agree that you're going to prevail at the end of the day, but I don't see how it divested the district court of jurisdiction of even hearing the Frost petition.
Well, Judge, on that, if I want to look directly at the order that was entered dismissing the case, it dismissed the case because under the statute, you can't bring an independent action out of a divorce case, paternity case. That was the basis. In that respect, the court didn't have jurisdiction. And in fact, on top,
The Frosts are saying that that conclusion was wrong though. And that gets
well, of
back,
course, of course
that
they are.
basically gets us back to, was TNA correctly decided, TNY or whatever?
Well, and that's, at this point,
I don't
TNY,
see how we
on
can
top of that,
hear your case without, I know that's ancient history, but I'm struggling with how we can hear your case, this case, without going back to those issues.
well, I think we can hear this case without going back to those issues because this case is very different than those cases. I mean, if we at this point, the TNY case and then the Baker case, they're the cases that have evaluated this statute in light of the amendments. They haven't been, the Baker case, they sought review, it didn't get taken up. So at this point, we have a statute that says X. You can only file an independent action in these circumstances. We have two cases thereafter that don't change that statute, at least in terms of this case. So, and to get back to the beginning, in terms of the ripeness conversation, we have a sync order that determines these grandparents can't have any contact. And the idea that they could get a visitation order over here and that visitation order could sit around for maybe a couple of years and then be in effect when the sync case goes away, it's just not a practical reality, because at the end of the day, they have to have a hearing on whether it's even still in the best interest of the kids to have contact with grandpa and grandma. That's why this entire case is premature. Even if they were to grant him the grandparents' visitation, by the time the sync case ended, they'd probably have to have a whole nother hearing. So basically what council wants is to have multiple hearings on what's in the best interest of the kids in terms of the grandparent visitation, because that's the exact standard that the sync court looks at, what's in the best interest of the kids. That's the exact thing that an independent court would look at in terms of visitation, what's in the best interest of the kids. And on top of all of it, what's in the best interest of the kids changes depending upon their growth and maturation and situation in life. That's why at the end of the day, we're here not because of visitation specifically. We're here because the appellants don't like the sync court, because they could do all of this same stuff right there. Council's already admitted they can get temporary orders of visitation in the sync court. He's already admitted that.
Okay, counsel, unless there's additional questions from my colleagues, I need to cut you off because we're going way over our time here. So
Very good. Thank you.
I'm hearing no further questions. So Mr. Baker, we'll go back to you for your rebuttal.
Judge Malone, let me say that TNY didn't say you couldn't file independent actions. In fact, it said, I think, precisely the opposite. It struck that limiting language that said that they construed it can only be filed in a dissolution proceeding. They struck that. What did that leave? It left a statute that said there was no limitation, meaning you could file an independent action, you could file it in a divorce action, you could file it in a paternity. That's where they left it. And so that's where that is. Now, so as to relief, the statute doesn't say you get relief from the interested party, you get relief from the district court. That's the one that gives you the relief. And that's why you give notice to the interested parties. As to the idea, I mean, I tried to get grandparent visitation in another kind of proceeding not named dissolution. And Judge Leben said no. So I cannot go to the sync court and get these statutory rights. Now let's talk about due process. The Frosts never got their day in court in the sync proceeding. You have the transcript. There was no hearing. There was no due process. We didn't get to put on any evidence. The court never said the Frosts don't have a substantial relationship. They never said that. In fact, the court sua sponte just said, oh, by the way, you not only not get visitation, you'll have no contact as an ex parte order. And oh, by the way, it goes against your counsel too. You can't even talk about it. So There's no due process there. They did not determine grandparent visitation. All grandparent visitation is not created equal. It's
Mr.
just
Baker, did you file a motion for grandparent visitation in the Cinque Court?
When I got the case, Judge, the court had already determined that, had said initially that the Frost would, that KCF could give them visitation. Before I could even ask for it, the court in that transcript came in and said, not only will you not get visitation, you're not have no contact. So that order was already made before I could even get a chance to do anything there. But
So the answer to my question is that you have never filed a motion for grandparent visitation in the Cinque Court.
I have done something like that. I've asked the court to undo what she did on the no contact. But I have not filed for the statutory grandparent visitation rights. No, because Baker v. McCormick said you can't do it. So I filed this independent action, which the district court said he didn't have jurisdiction, which I think is wrong. They do have jurisdiction. They can hear it. Whether or not he can provide that the orders he provides, he can still provide the orders based on a day in court, substantial relationship interest, something that the Cinque Court is not required to engage in, something that court did not engage in. And so you cannot say if there's a Cinque proceeding that grandparents are cut out of grandparent visitation, they cannot have an independent action. There's nothing to suggest that they can't make orders. It simply says that if he does make an order, they're held in abeyance. Cinque orders prevail while they exist. And that's all it says. Otherwise, you're going to have an outcome where children in Cinque proceedings have no grandparent visitation, cannot file an action, cannot get any relief, even though that Cinque court has no ability to provide that right in the Cinque proceeding, according to the Baker v. McCormick. And I don't think that complies with due process or what this statute says. TNY should not be followed in terms, or Baker v. McCormick should not be followed. TNY simply said that language is out. There's no limitation. Therefore, you can file an independent action. You can file it in a divorce. You can file it in a Cinque. You can file it anywhere.
I don't think
child custody claims.
I'm sorry, but TNY seemed to be pretty clear that they could only intervene in a divorce case, and then they extended that to a paternity case. I know that the remedy was striking the language, but if you read the decision, it's pretty clear that it's holding that you can only intervene in those two types of cases.
Well, Judge, let me disagree with you. They struck the language. They said there's no limitation. So what was the case presented to them? They had a paternity case. They said, well, because there's no restriction, sure, you can file it in a paternity. That's all it purported to hold. The next inquiry was what happened in Baker v. McCormick, and they said, oh no, there's still a limitation, a dissolution, and we're going to add paternity. We're going to rewrite that statute. That's Baker v. McCormick. I think that one got it all wrong. I think even if you adhere to TNY, striking that, however you want to do it, there's no limitation. I could file and so declare it, and I can address all the issues then with the other panel members. If there's no limitation, let me go over to the, I can file an independent action, and I can ask for that in the Cinque proceeding, which so far I'm prohibited by law from doing. So those are two distinct avenues. Those are two distinct statutory remedies that are not available in the Cinque, no matter, you call it grandparent visitation. Frost didn't get their day in court, and they cannot get statutory rights that are stated in this statute in that proceeding, and nothing that Cinque court says can affect that. So the district court was wrong. You've got jurisdiction. That court can enter orders. It has jurisdiction, and you should reverse and remand the case back. So declare, so that grandparents know they can file independent actions, and they're not limited to what Baker v. McCormick says are dissolution and paternity.
All right, counsel, thank you very much for your briefs and your arguments. Complicated case. We'll get a decision out to you just as soon as we can.